Hey everyone, I wanted to sort of give some feedback on this debate over the private members motion. You know, it actually gives you an opportunity to look at the Constitution and try to understand it a little more. The reason that this debate is happening is because the leader of opposition has a view on the notice period being satisfied, and the deputy speaker has taken a different view that the notice period was not satisfied. So if you take a step back, the Constitution actually sets out that the Parliament can make its own rules, right? So those rules are called standing orders, and so they cover the regulations and conduct of business in the Parliament. And so when you look at the rule for motions, that's covered under Standing Order 24.5. So that standing order basically says, if you want to submit a motion to the Parliament, you'd have to submit it at a previous sitting of the Parliament, or you would have to give it to the clerk of Parliament. But in those cases, you have to give not less than 5 clear days notice. And so if you read the letter published by the Deputy Speaker yesterday, you will see that she's saying that the 5 clear days notice was not satisfied. And when you continue to read that letter that was published, you'll see that she also includes a copy of a notice that was sent to her. And in that notice that was sent to her, it says that weekends are excluded from the count of 5 clear days. So basically, the notice was submitted on a Friday. And so according to the rules, you don't count Friday. And according to the notice that the Deputy Speaker received, that confirmed that weekends are not included in the count, Saturday and Sunday weren't counted. So based on the letter that was published by the Deputy Speaker, that means that only Monday, Tuesday, Wednesday, and Thursday are counted. So that's 4 days. The rules don't allow you to count the day of the House of Parliament. So basically, today they're going to meet, so you can't count today. That's why you can only count Monday to Thursday. So the Deputy Speaker basically concluded that, based on the standard usage and practice of Parliament over the years, Parliament basically hasn't met Saturday and Sunday. And, based on the notice she received, Saturday and Sunday are not included in the count. Now, when you look at the other side of the coin, the leader of opposition is saying, well, I agree that Standing Order 24.5 says that 5 clear days notice is required. But what the leader of opposition is saying is that, well, I disagree that the 5 clear days notice excludes Saturday. So the difference in the count is this. The leader of opposition said, if you want to understand what clear days means, since it's not defined in the Constitution and since it's not defined in the standing orders, you have to look at the Interpretation Act. And the leader of opposition then quoted the Interpretation Act, which basically says that you exclude Sundays and you exclude public holidays, but you don't exclude Saturdays. So when the leader of opposition did his count, the date of submission, Friday, was excluded. However, Saturday is included. So for the leader of opposition, Saturday is day 1, Monday is day 2, Tuesday is day 3, Wednesday is day 4, and Thursday is day 5. You don't count you don't count today, which is Friday, the date of the meeting, because the rules don't allow you to count today. So that's why that there is this controversy and difference in views, and that's why the leader of the opposition is asking the Deputy Speaker to reconsider her position, because the leader of opposition feels that his calculation of the notice period is correct. So that's just to give you a little summary of why there's a difference in the view. and it's just based on the rules, right? So if you read the rules, you read the parliamentary orders, those are available on the internet. You just search for parliamentary orders 2022 consolidation for our House of Parliament in Cayman, and you will get a chance to look at those rules. And it's so interesting when you look at those rules, because if we didn't have the Interpretation Act, for example, those rules say that basically you look at Section 88 of those parliamentary standing orders. It says that you'd have to actually look at the UK and see what the House of Commons does there, in terms of what their standard and usage of practice is, as long as that is not inconsistent with our standing orders, and as long as it's not inconsistent with our standard usage and practice of Parliament. So I would encourage all of you to head down to the House of Parliament today, October 7th, and hear what the debate is about. You may get a surprise, because when you look back at the Hansard, which is the transcript of all those speeches in our Parliament, you'll see that sometimes they can suspend standing orders. So for example, if they decide to, or if it's possible to suspend standing order 24/5, what will happen is then the members of Parliament will then do a vote, right? So they'll vote, and if the vote passes to suspend standing order 24/5, that means that they suspend the requirement for the notice period. So it'll be very interesting to see what happens today. I suggest you guys go down and enjoy it.